Right, good afternoon, councillors and ladies and gentlemen, and any resident who's watching, public watching on live stream. Thank you all for coming to the planning meeting of the local area council. I'm Councillor Bainan. I'm chair of local area council, but it's normally Councillor Foster who chairs planning, but unfortunately Councillor Foster couldn't make it today, so I'm stepping into the chair. Just to say that obviously COVID compliant, and this is being streamed live on Northumberland YouTube. First of all, we'll go to the agenda. Can we have apologies for absence, please?
I've received apologies from Councillors Foster, Jackson and Towns.
Jones, Councillor Jones.
And Councillor Jones. Thanks, Councillor. Disclosures of members' interests. Councillor Wearmouth first, then Councillor Bourne.
Thank you, Chair. So just to make it clear, I think that it's been raised that one of the applicants has maybe stood for political office in the last election. Just to make it, and I think it's been observed that I've signed a bit of paper in that process. So just so that people understand the way that these things work, is that anybody who wants to stand for a political party has to have a signature from someone that is called a nominating officer. Now, that nominating officer is someone that's assigned by a national political party to allow a party emblem to be used in the election process. And I, as chairman of the Conservative Party in Northumberland, have to sign for every single person who wants to stand as a Conservative Party candidate, whether who has been selected. So just sat in this room, I can see a good number of people who I've had to sign a form for in order to allow them to stand as part of the legal process. That doesn't mean that I know them or even like them, though I'm sure I like everybody that I meet. But it is necessary from a legal perspective, and it's not something that I have a choice in that where local people or parties have selected a candidate. It's just part of the legal process, and so I've had to do that for one of the people who is part of an application that's been considered today. I don't consider that to be something that's prejudicial to the process, and I'm happy that I'm going into considering the application and applications at this meeting with an open mind and ready to listen to the debate with interest.
Thank you very much for that, Councillor Wearmouth. You've explained that perfectly. Councillor Bourne.
Thank you, Chair. Very similar declaration to Councillor Wearmouth. Same individual, obviously I was aware of because he stood for election at the same time myself. I know of him, but I wouldn't describe him as a close friend. He's not discussed this application with me, and I've had no prior dealings with him regarding this application, so I don't see myself as prejudiced, but I thought I'd declare that I'm aware of the individual and know him.
Yes. Thank you for that, Councillor Bourne. Councillor Dunn.
Thank you, Chair. It's not a declaration, it's just to say I've just had a text message from Councillor Dickinson. He's stuck in traffic and should be here in a few minutes. Right. So if we talk slowly, he might get in at the beginning of the...
Talk quickly, we'll get it over before he arrives. Thanks for that, Councillor Dunn. We can add that, and that he arrived late. If we are have started an application, Councillor Dickinson won't be able to take part. Yeah. So we'll remind him of that when he arrives. Thank you for that. Determination of planning applications. The first one, which you have on your sheet, is 19/03659/Verico. Brockenfield Airdrome, Eshott, Felton, Morpeth, and I believe Mr. Horsley is taking this one.
Okay,
Horseman.
Yes, Jeff Horseman, yes. Yes, thank you, Chair. Right, okay, presentation for this particular item this afternoon. Will take a little while because there are quite a few updates to give you from when the report, the officer report was sent out to you. But first of all, before I get into those updates, just take you into the presentation and just a little bit of background in terms of the site itself. So you've got a location plan there showing where the application site is. Application essentially relates to the Eshott airfield site, which lies in open countryside to the south of Felton and West Thurston and the River Corket. You have a woodland burial site and the A1 to the west of the airfield, the hamlet of Bockenfield to the immediate south, and farmland and other scattered dwellings to the north and east of the sort of site. Just a couple of other slides, just in terms of showing the wider locality there. So you can see Felton and West Thurston to the north of the airfield, which is in the centre of the sort of picture. The A1 to the west. It's an aerial photograph view there of the sort of site. In terms of the site itself, the airfield site comprises a clubhouse and car park in its southwest corner. So you can see a couple of photographs there of the existing clubhouse building and the sort of car park. There are also various hangars grouped around the southeast and south central areas of the site, and the remainder of the site is taken up by various runway areas. Site is accessed from the A1 to the west. So again, just some other photographs. So few there north across the airfield from the southeast. A runway view looking south, a runway view looking east, and again some photographs there of the hangar buildings within the site, and again another photograph there of hangar buildings. And
Jeff, sorry, could I interrupt? We've just had Councillor Dickinson has just arrived. Normally, if you arrive in the middle of a presentation, you can't take part. But seeing we've just started, it'll only take a minute. Would you like to start your presentation again, please?
Okay, that's fine.
Apologies, Chair, I'm stuck in traffic.
Okay, so just to begin again in terms of the application site itself, as I say, the application before you this afternoon relates to the Eshott airfield site, which lies in open countryside to the south of Felton and West Thurston and the River Corket. You've got a location plan there on the screen of the application site. In terms of the immediate surroundings, you have a woodland burial site and the A1 to the immediate west of the airfield. To the immediate south, you have the hamlet of Bockenfield, and to the immediate north and east, you have farmland and a number of scattered sort of dwellings within the open countryside location. In terms of the airfield site itself, just some slightly wider scale photographs there showing the site in relation to Felton and West Thurston, an aerial photograph slide there. In terms of the site itself, in the southwest corner of the site, you have a clubhouse building and car parking area, just shown on the photographs on the screen in front of you. There are also a number of aircraft hangars grouped together in the southeast and south central areas of the site, the remainder of the site being taken up with runways of one sort or another. Photographs, again, some photographs here of the runways, a few there north across the airfield from the southeast. A runway view looking south, another view looking east, and then some photographs of the existing hangar buildings on the site. And then the final photograph just gives you a view of some of the dwellings in Bockenfield, the hamlet to the immediate south of the site. You can see one of the aircraft hangars on the right-hand side of the photograph there. Okay, so that's just a brief description of the site itself. In terms of planning history, there is a section in your report that covers the planning history of the site. The airfield itself dates back to World War II, when it was used as a Spitfire sort of training base. However, following World War II, use of the airfield ceased for quite a number of sort of years, and that brings us forward to 1995, when planning permission was granted by the former Castle Morpeth Council for use of the site by light aircraft and microlights. There's a reference to that 1995 permission in your report. Coming to more recent sort of times, planning permission was granted in September 2018 by this committee to vary conditions on the 1995 permission. Those changes included extending for a temporary period of 12 months the times when aircraft could land, take off and move around the airfield. Those hours were extended, as I say, for that temporary 12-month period in September 2018 from 9 a.m. to 7 p.m. to 7 a.m. to 11 p.m. Although circuit training and emergencies were excluded from those extended hours. That permission essentially said that once that 12-month period expired, which it has now, so it expired in September 2019, the permission said that after that time, we simply reverted back to the 9 a.m. to 7 p.m. Sort of hours. So just a brief overview there of planning history. As I say, the details are in your report. Moving on to the proposal. Again, this is covered in your report, but briefly, the application before you today is made under Section 73 of the Town and Country Planning Act, and again is to vary Condition 2 of the 2018 permission to allow extended hours for aircraft movements, but for those extended hours to operate on a permanent basis, with those revised extended hours being 8 a.m. to 8 p.m. No changes are proposed in terms of training activities and emergencies. Those remain excluded from those extended hours as per the previous September 2018 permissions. That's the proposal for which approval is sought. That's before you today. Moving on to consultations, consultation responses we've had on the application. You'll note from your report that there are objections to the application from both Thurston and Felton parish councils, and a summary of those objections is provided in your report. Your report also refers to 109 objections from members of the public, 167 representations in support of the application. Again, those are summarised in your report. By way of update, since your report was sent out to yourselves, we've had 10 further letters of objection and 1 further letter of support. In terms of new issues raised over and above those that are already covered in your report, new issues raised are essentially as follows. There is a request that an independent aviation expert is appointed to review any management plan. Were you to support the application today, you'll notice there's a management plan condition recommended. Also a reference to the County Council needing to enforce current alleged breaches at the airfield which have been reported to us, and a request that a noise abatement procedure condition should be added if members are minded to support the application this afternoon. One of the further letters of objection that has been received is from a local resident, but also contains advice that that local resident has obtained from legal counsel on the proposals, and in particular the wording and content of the officer report that's before you today. In summary, that council advice that a local resident has provided us with, in summary, requests 5 matters in particular be considered by the committee this afternoon. I'll just run through those one by one. Those 5 requests. First is, if the committee approved the 8 a.m. to 8 p.m. hours, this must be for a trial period of 12 months and must have the correct monitoring in place to assess the impact on residents. Secondly, the wider impacts of the application need to be assessed for the neighbouring settlements, not just the immediate properties, due to the significant change in aircraft noise since the original application. Order noisier aircraft helicopter activity reference in particular. And there's an assertion made that the County Council are underestimating the level of harm to neighbouring settlements in that regard. Thirdly, the management plan must be robust, clear and concise to enable NCC, County Council, to take enforcement action should it not be adhered to. Fourthly, a comprehensive circuit pattern must be put in place which avoids surrounding settlements from low-flying, overflying aircraft, which the County Council does have the authority to request and act upon should it not be adhered to. And then finally, an independent acoustic noise consultant should be appointed to assess the impact on neighbours and the surrounding settlements. That advice from Council also questions the validity of the noise assessment methodology that's been adopted by the County Council's Public Protection team in their assessment of the application. I do have my colleague Gary Park here this afternoon from our Public Protection team, so I'm sure later on, in terms of questions, if you have any questions around the detailed methodology of how the proposal's been assessed in terms of noise impacts, Gary will be able to advise you further on that. Reference is also made in that correspondence from Council that the committee report has not fully assessed non-emergency training activities at the airfield and visits to the airfield by aircraft over the 5,700 kilogram weight limit that's referenced in your report. I'll cover those matters later in my presentation when I run through the key issues. Finally, some rewording is suggested in terms of conditions 2 and 3 in your report. Officers have considered that, but we don't consider that the rewording that's been suggested by the residents' council to be necessary. Moving on, again in terms of updates on consultations, we've also received updated comments from our Public Protection team to those that are in your report. So that there has been recent reconsultation undertaken on the application. The application, when it was first submitted to us, you'll see it's been with us for quite some time. When it was first submitted to us, the proposed hours were 7 in the morning until 11 at night. Late summer, the applicant advised us that they wished to change the extended hours that they're seeking approval for from 8 in the morning until 8 at night. That's the proposal before you now. So it's not 7 in the morning till 11 at night as it was on the previous application in 2018 and as it was on this application when it first came into us. The proposal now is for extended hours of 8 in the morning until 8 at night, as I advised earlier. But essentially, in terms of further comments from our Public Protection team, those have been sort of received. They've had regard to further representations that we've had on the application and the revised sort of hours, the further information on more recent flight activities that the airfield has supplied, which again is detailed in your report, and have advised that, that their recommendation doesn't sort of change from that which they've given in their earlier comments, which are detailed in your report. Just moving on now to sort of key issues for your consideration. I'm not intending to go through these in huge detail. All of the detail is in your report, and there's a fair amount of material there which I'm sure you've had a chance to look through. But first of all, in terms of key issues, just to really reiterate to you that this is an application under Section 73 of the Town and Country Planning Act to vary a condition on a previous planning permission. Now, the Town and Country Planning Act states that as a local planning authority, when we're considering applications such as this, the only question that we are to be considering is the question of the conditions subject to which planning permission should be granted. And if you decide that planning permission should be granted subject to conditions differing from those subject to which the previous permission was granted, or that it should be granted unconditionally, then you should grant planning permission accordingly. If you decide that planning permission should be granted subject to the same conditions as those subject to which the previous permission was granted, then you should you should go for refusal of the application. So that's just outlining for you what the legislation says about these types of applications. I have to advise you as well, though, that should you decide to support the application this afternoon, the legal effect of approving a Section 73 application is that you are granting a new planning permission in respect of use of the airfield in its entirety, albeit subject to amended conditions. Now, in assessing the application this afternoon, you'll see from your report that that regard has been had firstly to the development plan, which comprises the Thurston Neighbourhood Plan, the recently adopted Thurston Neighbourhood Plan, and the Castle Morpeth District Local Plan. Other material considerations have also been considered, as detailed in your report, including national planning guidance, for example, in the National Planning Policy Framework, the emerging Northumberland Local Plan, and representations that have been received both for and against the application. You'll also note from your report that there are certain issues raised by objectors which relate to matters that are not under the jurisdiction of the County Council, but are rather matters for consideration by other bodies or individuals, as detailed in your report. So those are covered in your report. I won't go into detail on those now, but an example is given as around the technical specification of runways and pilot behaviour in the air, and whether pilots choose to land. There are a lot of areas where responsibility essentially lies with pilots, with the Civil Aviation Authority having enforcement responsibilities if rules of the air are not being adhered to, or there are breaches of a pilot's licence in terms of their activities when they're in the air, as it were. Also of relevance in assessment of the application are previous planning permissions granted regarding use of the site, and therefore that the need in terms of what you're considering this afternoon to look at additional impacts arising from the proposed changes to condition 2, which are over and above what has already been approved on the site. As I say, we're not starting with a blank canvas here. There are previous permissions that have been granted, as I say, in 1995 and 2018 for airfield activities at the site. So what you're considering are the changes to what was approved previously, and what additional impacts those give rise to over and above the impacts that already arise from what has been previously approved. And as I say, an example in that regard, so coming to this issue around non-emergency sort of training, and I mentioned there were concerns that hadn't been sufficiently addressed in the report. Your report does advise that aircraft-related training is considered to fall within the terms of the previous permissions granted for airfield activity at the site. There's also reference in your report to flight data that's been provided by the applicant, That's been assessed by officers, as well as reports of out-of-hours flight activity provided to us by residents who've emailed us with details of events that have taken place at the airfield out of hours. All of that information is presented in paragraph 7.55 of your report, and in summary, it shows for two roughly 12-month periods from September 2018 to September 2019, and from August 2020 to July 2021, that a very small number of flights have been taking place outside of the 9 till 7 sort of hours. So the figures that we've had show 1.5% of flights. That's 45 out of 3,083 in the 2018-2019 period were in that out of hours sort of time scale. And then for the August 2020 to July 2021 period, we're looking at 0.6% of flights. That's 7 out of 1,213. There may be some in addition to that which relate to ones that have been reported to us by residents, but the overall picture is of a very small number of the total flights coming into and out of the airfield being during those times which are outside of the current 9 a.m. to 7 p.m. Sort of windows. Officers are also conscious of alleged breaches of the existing sort of planning permissions covering the site. These have been investigated by our planning enforcement sort of team, and it is accepted that there have been some sort of breaches. I mentioned obviously some out of hours flights outside of the 9 a.m. to 7 p.m. sort of window, but as I say, the view of officers to date is that that the harm arising has not been sufficient to justify formal enforcement action sort of being sort of progressed. If this application were supported today, it would allow for some of those breaches that we've had reported to us to be remedied, in the sense of extended hours being granted until 8 in the evening, until that extra hour in the morning as well, from 8 a.m. rather than 9 a.m. There are certain breaches that would not be remedied today if the application was supported. In that respect, we have had complaints around large helicopters, large military helicopters such as Chinook helicopters using the airfield for refuelling. That is not something that can be remedied under this application if you were to support the application today. That is because the use of the airfield by large aircraft such as that which are above this 5,700 kilogram weight limit is not something that falls within the terms of the existing permissions that can be varied. As I say, the original permission was very clear that the permission was for use of the airfield by light aircraft and microlights, and we wouldn't consider a Chinook helicopter to fall within the definition of a light aircraft, and it's certainly above the 5,700 kilogram limit that we've adopted as our definition of a light sort of aircraft. So essentially, if the airfield wished to continue having Chinook helicopters fitted for refuelling, then they would need to apply separately for full planning permission in respect of such sort of continued use if they wish to regularise that particular activity. So just coming in now to the recommendation. As I say, you'll see from the report that a few of you officers, having examined all relevant material planning considerations, it is our view that for the reasons detailed in your report, that the planning permission should be granted, but subject to different wording in terms of condition 2 from that which is suggested by the applicant, and also subject to further changes to some of the other conditions from the sort of 2018 permission. So I'll just run through now what those changes are that we are recommending in terms of conditions should you decide to support the application. I'm just going to put the conditions up on the screen so you can see what's being proposed. And say there are some updates here from what's in your report, so I'll run through those at the same time. So in terms of if we take the 2018 permission as the starting point, because that's the permission that this current application seeks to vary. Okay, so the recommendation of your office is that 3 of the conditions from the 2018 permission are amended. The wording is amended for 3 of those conditions. So the first one we'll deal with is condition 2, which is, as I say, the one about the hours of airfield activities that the applicant specifically applied to ferry. Now, the view of officers you'll see from your report is that yes, the hours of 8 a.m. to 8 p.m. should be supported, but that is on condition that before that happens, that a management plan is agreed in respect of activities on the airfield site. That's covered by a new condition, which is in your report, condition 3 in your report. So it's subject to that management plan being agreed first before those extended hours kick into effect. It's also subject to a temporary period of 12 months as well to allow continued monitoring of the impact of those extended hours on nearby residents, both adjacent to the site and in the wider sort of area. We are proposing some minor changes to the wording from your report. So I just yeah. So in terms of the hours of operation condition, I've included on the slide on the screen there the changes in wording from the wording that's in your report, and those are highlighted. So that's under proposed there on the screen. So they're relatively minor changes from your report. So where the condition in your report refers to circuit training being excluded, we've just extended that slightly to refer to all training school flight activities, including circuit training, continuing to take place between 9 a.m. and 7 p.m. So they're excluded from the extra hour in the evening and the extra hour in the morning. That's just following some further clarification we've had from the airfield themselves, who've confirmed that all their training activities will take place in that 9 a.m. to 7 p.m. window. And then we've just clarified as well later on in the condition that in this period between today, if you were going to support the application, and when that management plan is discharged, that essentially the hours that would apply would be the 9 a.m. to 7 p.m. sort of hours in that period, as would be the case at the end of the 12-month trial period after the management plan had been agreed. Again, you would just revert back to the 9 a.m. to 7 p.m. hours, unless, of course, the applicant in the meantime had submitted another planning application to have the hours on a permanent basis, and that had been approved by the County Council. So that's condition 2. And the second condition that we're looking to vary is the condition on aircraft sort of types. Now, the change here that's proposed from the 2018 permission, in the 2018 permission, there's still the same reference to the 5,000 kilogram weight limit in terms of aircraft. But in the 2018 permission, the condition exempted military aircraft and emergency services aircraft and aircraft in emergency situations. It exempted those aircraft from that weight limit. That weight limit exemption, now the proposal is to remove that in terms of this particular condition around aircraft types. The reason we're suggesting that that is removed relates to some recent case law that has arisen since the previous grant of permission in September 2018. During the course of 2019, there was a Court of Appeal decision around Section 73 planning applications, which essentially said that you really do need to stick quite rigidly to the description of development on the original permission. You can't go beyond that. And obviously, as I've said already, the original description of development from the 1995 permission refers specifically to light aircraft and microlight use only, so it would not cover use of the airfield by any aircraft which are not defined as light aircraft or microlights. So we've removed that, we're proposing to remove that exemption in terms of the military aircraft and emergency services aircraft, so that essentially the condition is now worded, simply says that no individual aircraft using the site shall exceed 5,700 kilograms in weight. Okay, so that's the second condition that we're proposing to vary, where you support the recommendation. The third condition that we're proposing to vary from the 2018 approval is a condition which relates to noisy machinery and noise from airfield activity on the ground. And so if I just get that on the screen. Right, yes, that condition doesn't change from what's in your report, but essentially the change from the 2018 permission with this particular condition is that we've just included some text now around the applicant undertaking noise monitoring if we as a local planning authority are satisfied from a complaint that we've received that such further monitoring is sort of justified. And any such monitoring undertaken by the applicant would have to be undertaken in accordance with the methodology that's been agreed by ourselves. So those are the three conditions where, as I say, we're proposing changes were you to support the application. As I mentioned earlier, there is a new condition proposed around a management plan being agreed. It's probably quite small, that text, but it's in your report. That particular condition, but there are a couple of updates that we're proposing to make to the management plan condition. So the first is in part 5 of the management plan condition. In your report, there's reference to a liaison committee, and that refers at the moment to the membership of that liaison committee, including the county councillor for Long Horsley ward. We're proposing to also add into the membership the county councillor for Shilbottle ward, which covers Felton. So that's a change there to part 5 of that condition. And then we're proposing to add a part 6 to the management plan condition, which essentially will cover arrangements regarding resources to be deployed and the allocation of administrative responsibilities to facilitate implementation of the management plan. So that's just to make clear that there will need to be some discussion around essentially making sure that the management plan is properly implemented through being properly resourced, whether that's having a member of staff within the county council or the applicant taking on some administrative responsibilities. There's a discussion that needs to take place as part of agreeing the content of the management plan in terms of how the plan itself will be resourced and administered, who's going to be responsible for what. So we're just proposing some additional wording there. And so that's the new condition. And then basically the other changes from the 2018 permission in terms of the conditions, we're proposing to delete condition 7 from the 2018 permission. Again, these are all in your report, these final matters, so nothing's changing. So it's proposed to delete condition 7, which was a monitoring condition, because essentially monitoring will now be dealt with through the management plan were you to support the application this afternoon. And then there are 3 conditions from the 2018 approval where there is no change proposed. So those are simply reiterated in your report in the officer recommendations. Those are conditions 3 around the maximum number of aircraft, condition 4 around outside storage, and condition 6 around external lighting. So I hope that just helps to summarise, as I say, the various changes to the conditions, because I know it can be quite difficult sometimes just to grasp sort of that. So essentially, just coming now to the recommendation, the officer recommendation is that planning permission be granted, subject to the conditions as detailed in your report, with the further amendments to conditions 2 and 3 that I've outlined sort of to you. Okay, thank you, Chair.
Thanks, Jeff, for your very detailed and excellent report. We go now to public speaking. The objectors have up to 5 minutes, which is split between however many speakers are. A local member has up to 5 minutes and the parish council has up to 5 minutes. The applicant or supporter, again, has up to 5 minutes. We go to the objectors first. And
Mr. Chairman, sorry, can I just make it clear that I have said that as the local member, I'm not planning to use this slot. I will speak during the committee proceedings, but I'm not going to be using this slot, so I will gift it.
thanks, Glenn. You weren't on my list anyway. So, but thanks for that, Glenn. First of all, we go to the objectors, and I think there's just one person speaking for the 5 minutes. Please accept my apologies if I pronounce your surname wrong. Sorry, Fiona
Krzyzosiak.
That's what I was just about to say. You have 5 minutes, and we will start the timer as soon as you're ready to speak.
Okay. The original application, to which we and many people objected, has now been amended 8 till 8. In addition, it has now been recognised that the 5,700 kilogram weight limit should apply to all aircraft. It has been proposed by the planning officer to put into place some additional monitoring and consultation conditions to ensure that the failure of the last trial is not repeated. We contest much of the planning officer's report content as recorded on the planning portal, but in a spirit of cooperation, we will support his recommendations for a 12-month trial, together with the additional monitoring and consultation conditions. However, the following caveats need to be applied to condition 3. The monitoring and consultation conditions need to be agreed by all parties with a formal terms of reference, and the vague wording of the attendees needs to be addressed. This condition 3, attendees, should include public protection officials who are responsible for NCC's health and safety matters at unlicensed airfields. Then it needs to be put into place, and it needs to be tested with some recent complaints to ensure that they will work during a trial. Only then should the 12-month trial clock begin. It would be nonsense to start a trial before any of these measures are in place and proved to be effective. As we are now approaching winter and dark, shorter days, this short delay to start the trial will have no material impact, so should be acceptable to all parties. We all agree the CAA have no regulation oversight and enforcement powers over unlicensed aerodromes. This responsibility is devolved to local authorities by way of planning consent and conditions, as well as a public protection responsibility under health and safety laws. This is an ongoing responsibility which NCC now understands. The management of ESHOT since 2016 makes grim reading. Since 2016, Air Accident Investigation Branch published at least 7 investigation reports in connection with Eshet Aerodrome. In 2019, French BEA report of 2 crashes involving Eshet aircraft, resulting in the deaths of a pilot and an 18-year-old passenger, were organised and planned from Eshet, in their own words, a crazy adventure. According to the report, none of the pilots had mountain experience. The surviving pilots attributed the cause of the 2 crashes to errors made by the deceased pilot, both within the report, then at the inquest. In 2020, there was a crash landing near Eshet village, but it was described location to the AAIB was Widrington. Police wasted 3 days investigating a reported deliberate slaughter by neighbours of a flock of chickens. Police visited and interviewed the adjacent neighbours as suspects, and a suggestion to them to look at CCTV footage realised that the killer was actually a fox. In 2019, a neighbour was falsely accused by Conservative MP Anne-Marie Trevelyan of endangering lives and aircraft by putting up a fence and straw bales, and this was during Prime Minister's questions in Parliament. The CAA later confirmed that this was nonsense. She later sent an apology to the landowner saying she had been misled. This same slander is repeated as a libelous statement by the all-party political group on general aviation, chaired at the time by MP and pilot Grant Shapps. The statement remains on the All Parties Group's General Aviation website. 2021, Brockenfield Aerodrome Limited sought damages of £207,000 and an injunction to cut down all of the trees at the adjacent neighbours. They lost their claim for any damages and their costs were reduced by 20% for causation, in other words, bringing a claim without merit. It was also reduced by 10% due to dishonesty during the trial. Only a very limited number of trees were trimmed or removed on the runway approaches only under terms of a property easement. 2 weeks ago, the latest crash landing was in Felton, only 230 metres from Dean Close houses. It is now under investigation by SBB Place. And finally, recently, as Friday, Felton Parish councillors witnessed an Eshet training aircraft low-flying over the settlement. Despite this being reported to Richard Pike and receiving a very sympathetic response, the same aircraft was recorded later that day doing exactly the same thing. Hopefully you now understand why Condition 3 needs to be watertight. Thank you.
Thank you, Mrs. Carosia. As Councillor Sanderson stated, he'll be saving his time for the debate. We have, for representing the Parish Council, Thurston Parish Council, Nicola Allen. As soon as you start, ready to start speaking, the timer will start.
I was shouting, now I'll put the microphone on. I do apologise. The Thurston Parish Council do recognise that the airfield is well established in the parish, and they also realise that it's now very much a commercial operation. And as a parish council, what they're seeking is a balance between the airfield business and the amenity of those in the parish. The case officers explained to you the history of this site, but the key point that members really should be aware of is that since the 2018 permission, the use of this airfield has materially and dramatically changed to the detriment of the area. The present situation, and it has rather been glossed over today, the present situation is that there are breaches of conditions. I know the planning officer has said that officers have advised not to investigate, but if members can imagine a Chinook helicopter being refuelled within 200 metres of a house, if your officers feel that that is not a serious breach, then perhaps your officers have a slightly different idea of what should and shouldn't be investigated or actioned. So I'd just ask you to have that in your mind. The technical advice, the appeal decision is very important. The appeal decision in 2007 was for a very, very modest application. It was for 4 microlights to land after 7 p.m. The inspector is independent, and he took into account, visited the site, and his findings were that the area was quiet and tranquil, despite localised noise from the A1, and he said that just this very small change in time would have an unacceptable annoyance to people in the area. And I say to you, nothing has changed since then. The first issue is evidence. What concerns me greatly in the Parish Council about this appeal, about this report, is that questions have been asked of the applicant, and the general response is always, "Oh, it'll be fine. Don't worry, it'll be fine. We've got a reason for that. We've got just a reason, really." The environmental health officer has said he's visited the site and observed takeoff and landings, but it's not just at the actual airfield where people are affected. It's very much in the wider area, and this is the biggest area of concern for the Parish Council. Much of the area is completely unaffected by the A1, but it is very much affected by the airfield. And that finding that the A1 is really important is completely at odds with the previous inspector's decision. So the key material considerations, noise is absolutely key because you are the responsible authority. It's not environmental health, it's not the CAA, it's not some other public protection agency. And basically, the situation we have now is that the applicant's a commercial operator who has been willing to breach conditions in the past, and therefore that has eroded the trust locally, and that is an issue. They're benefiting economically from non-emergency military use. The officer report tells you that. And they are seeking more intensive use of the site, and they are also telling you that disturbance has been caused during the extended hours since 2018. So it is inevitable that if you have extended hours and a more intensive use, that is going to disturb more people, more businesses, and more often. That's just plain as day. So the conclusion that your officer has come to in Section 8 is simply not made out on the evidence. I would urge you to look carefully at the evidence. The MOD letter has been mentioned. Basically, the MOD is saying that they're using ESHOT to access military-grade fuel, and it's the only one within reasonable range. That is actually not true. Newcastle International Airport sells the same fuel, and it can be accessed, and it's open 24 hours a day. What the MOD are telling you is that the airfield is significant in terms of training. That is not emergency use, and that's something that must stop. Just looking forward, the Parish Council do very much engage with the idea of having a management plan. They support it, they need it to work, and they need it to work for all parties. But ask yourself as members of this committee, will it work? And our suggestion is that the management plan must be agreed before any extended hours take place. And it must be properly drafted, it must be seen by members, and it must be signed off by them. And the Parish Council is very willing to engage in that process with you. Thank you for your time.
Thank you for that. We now go to the applicant, again, who has 5 minutes. And if you can switch your microphone on, please. We have Mr. Pike.
Sure. So I think we've heard there about how Ayrshire Airfield is basically one of the worst places in the world and run by some really nasty people. But I'd like the council to think about what your current view is based on what you've actually seen rather than some of the things you've heard. You see us do charity events constantly. You see us keeping the history of the site going. You see us doing educational programs and teaching students things that they can't see anywhere else. You see scout groups coming, schools coming to see what we do. You see cadet groups. And unlike a lot of applicants where they'll say, oh, this is what we're thinking of doing, we're actually already doing these things. We're proving that we are a good thing in the local community. And when it comes to the history in terms of the objections is very much the same. A lot of the same people who objected 20 years ago, and it's all for the same things. It's for illegal, terrible fuel. It's for pilots flying over houses and causing dangerous situations and all that sort of thing. It's the same people that you can read about in the minutes going back 20, 30 years. And I think about 85% of the local population love the airfield, or they don't care. And that's fine. If they don't care or they love it, that's great. 10%, they're the ones on the fence. They're the ones who occasionally have the genuine grievance here and there. Maybe a helicopter did upset them one afternoon, or something, something wasn't quite right. And you know what? We hold our hands up and say, yeah, occasionally we do make a mistake, or a pilot makes a mistake, or maybe there's a circumstance where actually that just needed to happen. And a priority at the time was not being quiet. 5%, they're the ones who hate the airfield, like the Surrey pair next to me who came and followed my friend's inquest when I watched two of my friends die.
Sorry, just to interrupt you, Mr. Pike, can we, keep sort of insults out of it?
Sure, we can. I think something to understand is the obsessive nature of some of these people that follow me and my colleagues around and going to inquests and things to try and upset us.
Point of order, Mr. Chairman.
Sorry, can you allow the...
Not if he's going to insult
I'm just
me.
about to say that.
Right, thank you.
So we can
in terms
keep the
of
insults out of it and just keep to the facts and your explanation.
Sure, yeah. Well, facts are why we're here, and that's why that particular pair of people shouldn't really be listened to at all. In terms of the sort...
Please, I've asked you twice.
Sure.
I will switch your microphone off if you do it again.
Okay. The trial period, then, we'll go back to that. I make it there was about 48 movements over that year. And that's just a handful. And it was on a handful of days as well. It wasn't every day. And some of those movements would have been 1 minute past 7 etc., etc. They're not all in the middle of the night causing massive disturbance to everyone. We've heard about the military and how they can refuel at Newcastle Airport. Well, no, they can't actually. They can't do that all the time. And during Operation Rescript, where the RAF was supplying ventilators and things like that to Sunderland Hospital, that's why we're refueling military helicopters. We're also refueling Pumas that were going up to help the air ambulance service in Scotland, who were overwhelmed at the time. And of course, my staff stayed on the site for 4 months. They stayed there, they slept there in isolation, and they helped to fuel those helicopters. And they did that with certain people bullying them. They had people online taking the mick when they were out playing with bow and arrows and things. There's people saying, oh, why don't you go and kill yourself with those bow and arrows? That was the sort of thing that my staff were having to deal with. Then we come on to, what the military have actually said. Well, they said we're vital, actually. They were the words they used, vital. And it's not just training at all. It doesn't work like that. And it's not an on or off service that we provide. The Coast Guard, for example, being another service that we provide, we do rotors running fueling, it allows them to extend their search in the local area. The closest helicopter being in Humberside, another one being at Prestwick. So that's quite a long way, and these things do need fuel, and they need fuel when they're extending searches. So next time, well, assuming this goes through today, and I think it will, I think you'll make the right decision, but unfortunately, so the Coast Guard now, we're not going to refuel because it's 5.7 tonnes. The helicopter's more than that. Do we not refuel the Coast Guard anymore? There's nowhere else in Northumberland to get that fuel. So we'll continue doing it. And we'll be putting in a new application to deal with that particular issue. Then we look at employment. Well, there's 5 new staff come to the site this year. Because, of course, the old adage that the airfield doesn't contribute to the local economy, well, that seems to have stopped recently when actually people have seen what we do and the positives that the airfield has. And activity does not always make noise, is another thing I would add. 5 of those people working in aircraft restoration, for example, that's just my 5 people. There's other businesses on site that have employed more. But my 5 people that are new, they work on projects now that are tens of thousands of pounds, and they come in, that aircraft will fly in, it'll spend 6-7 weeks
Thank you, Mr.
working.
Pike. Thank you for that. I know emotions do run high, but, you know, we're here to listen to the facts and appreciate it if the members of the public who are speaking could not insult other members. Everybody has their own view. It might differ from yours, but you have to respect that other people do have their views. Thank you for that. Right, gentlemen and ladies. Councillor Sanderson.
Thank you. This is just a question about the process now, if I may. Yep. I have got a couple of little amendments I want to make when we consider the management plan, because you can see that relations aren't cordial, and I think the management plan is something that we've been talking about for a long time, and it's hugely crucial that we get this right. So I will be bringing forward 1 or 2 amendments that talk about dedicated staff, that talk about a period of discussion coming back to this committee to be agreed before it's signed off. Do I do that now or at the end?
No, Councillor, what we'll be doing now, we'll be having committee members' questions to officers. Right. And then we will go to debate, and then after that, if you want to propose amendments, we can do that. Thank you for the voice.
Chair, if I could just add, in Councillor Sanderson, if you want to ask us questions about what you're going to propose, by all means you can at this stage, so that then the rest of the committee know what it is that you're going to ask. They can ask further questions on it, and then we can go into debate it at that next session.
That would be helpful if you don't mind, Mr. Chairman. Yeah. So essentially, 2 of the things that I would like us to hopefully agree tonight is around the point about the dedicated officer, who would be an impartial person, who would be the monitor and the conduit for people who have complaints, who have concerns, and indeed act as an honest broker if those concerns aren't necessarily founded in fact. So that's the first thing. So that Mr. Horseman did mention this, because I have raised it with him previously, and I think it is somewhere in there. But I want it to be, if necessary, a new resource identified with new funding, so that we actually make sure that we're taking this seriously and putting our money where our mouth is. The second thing, Mr. Chairman, was just around confirmation, and hopefully members will agree to this, that there needs to be a period of maybe a month or 2 for good, serious consideration to be taken about how this management plan will actually be will actually be serviced, and what key points will be discussed, and what processes and procedures will be part of it. And so the second point I wanted to make tonight was, if we do agree this, and if we do agree the first one, then the second one would be to refer this back to this committee, say in 2 months' time, once that work has been carried out, for us to then give our thoughts and views on that. So those were the 2 points.
Thanks, Councillor Sanderson. In our pre-meeting, we did discuss this, and it was my concerns as well about the management structure and also the costs, whether that falls on the county and whether people think that's fair or not. Liz, I don't know if you want to come in now and answer that.
I just want to check, Councillor Sanderson, you've talked about the dedicated officer. Is that a dedicated officer of Northumberland County Council? Is that the role that you see that person
It is,
take?
yes.
Yeah. So the papers that are before you and the recommendations that are before you today, members, is not we're not at that stage. What we would like to do in these next 12 months is work with the applicant, work with all of those parties that are mentioned in the liaison group, and pull together the management plan, and through that process understand what resource we need, who that dedicated officer would be. And if we then reach a position where the applicant returns to make these changes on a permanent basis, we would then be at that stage where we would introduce perhaps the dedicated officer, the resource and the financial implications of that. Because to be able to secure that through planning, you cannot do that through condition. It's got to be done through a legal 106 agreement. And to inform that properly, we really need to understand what it is that we're asking. So what we're saying is, it's not a no. This next 12 months needs to be a period of time where we can think about who that resource is going to be, where the best fit is, what the financial implications of that are going to be, and also to be fair and reasonable to the applicant as well, so that they have an opportunity to discuss with us what they feel about it too. And then when we get to 12 months on and we've tested this and we understand how that operates, we will then consider coming to you with that ask through a 106 agreement. If that depends on if that application comes forward.
Thank you. So this perfectly demonstrates there has been no pre-agreement on this point. I actually feel really strongly that we need to have this dedicated officer, but I would accept a compromise, which is that when this work is done over the next 2 months and the report comes back to this committee, which it really has to make sure we've got the management plan correct, we will then discuss the funding and resourcing of it. And I'd accept that as a compromise, not waiting for 12 months there. Thank you.
Thanks for that, Councillor Sanderson. I'll bring Liz. My concerns were the same of who will be paying for this service, if you like. Liz, do you want to answer what...
So I think really, in terms of what I think we're at cross purposes with what we're talking about here, because we're saying we'd like to trial this for 12 months so that we're very clear what what we can put in place to meet the needs of monitoring what's happening at the airfield and being able to be a liaison point for the residents and the airfield. And we think it's going to take that time to be able to sort that. If it is the case that members think that actually it needs to be sorted now and we need to have greater fleshing out of the management plan, then really in terms of you determining the application today, I think your option would be that you would be deferring it for 2 months to allow a position where we can then have discussions about this role and get more meat in the bones with the management plan. At the minute, you've got a framework there, but we don't have a full agreement, and that's what we're saying. We'd like the time to work that up. So that's something for members to think. Jeff?
Sorry, I'll just come back on the points that Councillor Sanderson has raised. As I say, in my presentation, I did mention that that we would be recommending today that this further point 6 is added into the management plan condition sort of wording that, as I say, deals specifically with this issue of arrangements around resourcing of the implementation of the management plan. So the recommendation that's being put to you this afternoon is essentially that if you support the recommendation, that there will be some additional wording put into that condition 3, which will require the applicant, when they come in to discharge that condition within the next couple of months with the details of the management plan, they will have to include some details on what resources will be put in place to make sure that the management plan is implemented. Now, as I say, that may involve some county council involvement. It may involve some involvement from the applicant's side as well. That's a discussion to be had as part of pulling together the details of the management plan. And in terms of the committee having control over what's agreed at the end of the day, again, if committee are of the view that they would want that discharge of condition application for the management plan to be decided by the committee rather than officers, then yes, as I say, that is a request that can be agreed to today as a condition of, as I say, approval being sort of granted, that any application to discharge that management plan condition is brought back before the committee for a decision.
Thank you. Thanks for that. I mean, we'll have more questions for officers, then we'll go to debate. And Councillor Sanderson, if you want to propose something at a later stage, we can. I've got Councillor Bourne and then Councillor Dickinson.
Thank you, Chair. Just to clarify, this is, as proposed, as a 12 months trial. But when is the 12 months running from? Would it run from today if we granted it, or would it run from when there was a discharge of the conditions? Or when does the 12 months run from?
The 12 months would run from when the management plan condition is discharged, approved by the County Council.
Thanks for that, Councillor Bourne. Councillor Dickinson.
Yeah, similar to yourself, Councillor Bennion, around the resource required to do this and actually who pays for that. Because actually, if approved today, there is some benefits and potential negatives, and there is a lot of local concern about impact and things like that. I remember the first time this application came a few years back, and we had a report to committee afterwards, pretty much along the same lines as Councillor Sanderson referred. And I do think it is important that those types of plans come back to committee, because it gives a greater scrutiny than what might have been done and then passed to an officer for approval. Not suggesting that officers don't give good, robust challenge to these, but I do wonder, Liz, where the intention would be with that and why that isn't just automatic. I think the other question I've got, Chair, is I would much rather have had a draft plan than no plan at all attached to this, so I could see the trajectory of where we were going, see who's going to facilitate and manage the liaison group and all the things that have been said in this report. I do think the conditions are robust in this, Liz, and I think they need to be, but I just wonder how robust they're going to be in terms of the monitoring and feedback on some of those, because they are quite, I would assume, time consuming and resource consuming for the authority to carry out. So I'm assuming that's all been taken into account with fees and such like in relation to the application. But I'd just like clarity on that, please.
Liz, do you want to come in on, or Jeff?
Yeah, Jeff might want to add to this, but in terms of, you know, I think what this discussion is really focusing on is that you're thinking about having a point of contact officer who is there coordinating complaints and discussions between ourselves, residents, and the airfield. And like Jeff said, we did discuss this ourselves, and that is why we've put in that condition part 6, bullet 6 of condition 3, to give us that extra discharge on the applicant, where we've got to reach agreement between the LPA and ourselves with regard to the resource. just thinking out aloud, that the difficulty with that is that I think what you're also looking for is recompensance for that, and that's the difficulty to achieve that through a management plan, as opposed to having it wrapped up in a legal agreement to be able to secure it. So we could possibly work up an agreement where there is a lead officer here at the council, but it would take us until they came to formalise the permanency of the change that we'd be looking at a legal agreement. I don't know, Jeff, if you've got any further thoughts on the sort of financial implications of that.
I think just to respond directly to Councillor Dickinson's question, we're not starting from a kind of blank canvas here. There is a certain amount of work that has already been done in terms of the management plan. The airfield themselves have produced a first draft of the management plan, which was published on our website, and we've had a number of comments from residents and the parish council on that sort of draft. And as I say, the wording of the management plan condition that's in your report, together with the changes we've suggested to that's very much come out of the discussions that have taken place already. I think all we're saying is that there's further detailed discussion that needs to take place to really pin down exactly what these different sections of the management plan will cover, which are kind of detailed in your report. And this further section 6 has been mentioned about resource. So there's some further detailed discussion that needs to take place. The airfield themselves, for example, are still undertaking work at the moment, which will feed into that kind of final action plan. So for example, when we look at the issue of circuits that's been raised, in terms of low flying and overflying of residential properties, the airfield at the moment are going through a process whereby they're looking at changing some of their circuits, but that work hasn't finished as yet. But that's some of the work that will feed into the kind of final action plans looked at through this condition when they come into discharge. I think it's just making the point that, as I say, some work has been done already, but there is detailed work still to do, and we feel that that's best dealt with through a condition on a permission. And as I say, if as members you feel you want to retain control over that process because of the importance of the issue to residents, then yes, by all means we can accommodate that discharge condition application coming back to committee for final decision in terms of the detailed content of the management plan.
Thanks for that, Jeff. Councillor Dodd.
Yeah, a question. It's about the funding of any surveys, stroke, whatever. There's more than aircraft make noise. And I say this because I sit on Newcastle Airport Committee. And a good percentage of the time spent there is addressing noise by a group of residents from Heading on the Wall. That's in Northumberland. Now, I don't want to get us bogged down into whatever, wherever, but if we set a dangerous precedent somewhere along the line, it's going to bite us very hard.
Thanks for that. Councillor Wearmouth.
Thank you. So, I've got quite a few, I'm afraid, and hopefully you can hear me. So, firstly, I remember discussing this a few years ago now, and it wasn't an any easier discussion then than it is now. What happened to the 12-month trial, and are there lessons to be learnt so that we're not sitting doing another 12-month trial in another 12 months? Can that just be clear that you're confident officers that this is going to get to the nub of things? Because it must be torture for both parties, and clearly they're agitated.
Yes, I think on that particular point, as I say, yes, we did have an issue with the previous permission that, as I say, the monitoring condition, as I mentioned in the presentation, wasn't sort of complied with. That's why in this instance, we've made very clear in terms of the 12-month sort of period that only kicks in once the management plan has been discharged. The management plan condition has been discharged. So as I say, the extended hours cannot sort of lawfully take place until that management plan has been agreed.
Thank you, because I can't remember for sure, but I think I made that point at the time. So if you're doing that this time, that's great. Just wanted to make sure. Breaches. When it comes to the breaches, what type of breaches have there been of the previous? Are we talking really always flights, and is it or is there something else? Or you know, can you give us a flavour of the nature of the breaches that are encountered?
Well, as I say, they probably fall into sort of three kind of broad sort of areas. So, as I mentioned in my presentation, that there have been some breaches of the hours when aircraft can land, take off and move around the airfield. So, as I say, under the terms of the previous permissions, the currently permitted hours were back to the 9 in the morning until 7 at night again. So that there clearly have been some instances, exception rather than the rule, as you've seen from the figures presented in your report, where aircraft have been landing, taken off, moving around outside of those sort of hours. We've had complaints as well around, again I mentioned, around aircraft that exceed the 5,700 kilogram sort of weight limit using the site. I meant to give the example of Chinook military kind of helicopters coming in for sort of refuelling, so there's that. We've also had complaints that there's a condition around noise on the airfield site from kind of non-aircraft related activities, so we're talking there about, for example, the airfield, for example, have trucks that they use to kind of store fuel and dispense fuel from. So we've had complaints about the noise from those sort of trucks of being above this noise limit that's set down in one of the conditions from 2018. So as I say, all of those complaints have been investigated. It's not the case, as was alleged earlier, that the complaints haven't been investigated. They have been investigated by our planning enforcement team. But after they've been investigated, obviously a judgment then has to be made as to whether or not, even if there has been a breach, whether or not it would be expedient to take enforcement action. And the view has been taken that it wasn't sort of expedient. So nobody's saying here that that there haven't been occasions where some nuisance has been caused to residents and that there's been a breach of conditions. But as I say, we wouldn't necessarily take formal action if a condition is breached. We have to, our planning enforcement team have to look at the expediency of taking enforcement action. Enforcement action is a discretionary sort of role. The council don't have to take action if there's a breach. So that's a flavour anyway of some of the things we've had.
That's clear. One of the people who spoke against, I think, mentioned some QC recommendation or other regarding the 8 to 8 hours. I can't remember quite what the point was, and obviously now we can't ask them. But I couldn't really understand what the difference was in terms of what the QC was suggesting, or whoever it's been, around that limit versus what we've got. Can you explain very briefly, if you can work out what I'm on about, what you consider the difference to be from the representation from residents or from the parishes or whatever it is in that particular limit versus what we've actually got?
No, I'm struggling to.
My apologies.
As well, yeah.
Yes.
Chair, if I may, I think during your presentation you mentioned that subsequent to the papers, you received a letter from a resident that had taken advice from a barrister council.
Yes, correct.
And that this barrister's advice was about this time limit. Was that what?
Yeah, I was just trying to understand what the difference was. I couldn't quite. When I listened to the explanation, I think it was from the resident. I couldn't quite work out what the actual difference was between the one and the other.
Well, the representation that was made in the council advice that the resident had obtained, and this was in the summary of what they were wanting the committee to agree to, simply said that if the committee approved the 8 a.m. to 8 p.m. hours, this must be for a trial period of 12 months and must have the correct monitoring in place to assess the impact on sort of residents. And that's what we're proposing, as I say. We're proposing, as the applicant has requested, 8 a.m. to 8 p.m. It will be for a trial period of 12 months, and that 12 months will start, as I've said, from when the management plan is agreed. And the management plan is essentially that mechanism, that monitoring sort of mechanism, because the management plan is around, parts of the management plan relate to monitoring activity on the airfield site, such as the circuit routes, by example, the dealing with complaints, managing complaints. So I think what's being asked for there is something that we're providing for in terms of the recommendation.
So yeah, okay. So you feel you're aligned there, because I didn't really understand why that, what the difference was there. Is it the, and can I just understand then? And sorry for so many questions, but it does show that I either wasn't paying attention or that I am paying attention, one of the two. When it comes to what the application was actually asking for, it was asking for this 12-month period, was it? Because, or was it asking for something longer? Is that something that we've imposed as a result of this?
No, the applicant was wanting the extended hours on a permanent sort of basis. That's what they've applied for. But as I explained in my presentation, the Section 73 of the Town and Country Planning Act, which is what this application is being considered under, because it's an application to vary conditions. Essentially, that allows the local planning authority to impose different conditions to those that the applicant has applied to have changed if we feel that is necessary. And we do feel that is necessary in this case. We don't feel as officers that it's appropriate for a permanent extension of the hours to be permitted at this point in time. We do feel that there is still a need for a temporary 12-month period backed up with a management plan to allow further monitoring of those extended hours before a permanent permission to be considered.
Next one. So training flights, I'm sure that the applicant would be able to explain this, but how do you know when they're training flights and when they're not? Is it just simply a code, or how are you going to track that, because those are on different times?
It would essentially come down, I think, to, obviously, if we have complaints to our planning enforcement team, obviously they would need to investigate those and have those conversations with the applicant as to the nature of those sort of flights. There will be certain distinguishing characteristics I would have thought that you would have with training flights as opposed to your kind of standard flights. So by example, a characteristic of training flights is you'll be flying a circular circuit, and you'll go out and you'll go around, come straight back in again. You touch and go sort of landings and takeoffs, which obviously you're not going to get with someone who's as I say, just using the airfield to head off elsewhere, or they're coming in from elsewhere in the country. So there are those kind of characteristics. Again, another type of training that the airfield operators kind of helicopter sort of training, and again, a characteristic of that is you get instances of helicopters hovering a short distance up and down above the ground, which again you wouldn't get if someone was leaving the airfield to go elsewhere or coming into land. So there are those kind of characteristics, but it would be for the planning enforcement team to obviously look into the details of any complaints that we get to try and distinguish the type of flight that's taking place.
Just to add to that, Councillor Wearmouth, in the management plan, we could, again, add more to point 3 of that, so that they make it clear on the log what the flights are, whether it's a training flight or what have you. So, just to help with the monitoring reports.
I suspect that's probably how it's done, I would think. So that might be a logical thing to add in. Thank you, Liz. Now, I've only a very few more, to promise. Noise limits. So perhaps over to the EHO. In terms of what's been experienced at the minute, do we have limits? Are they breached? And because there was a point made about there's all these more flights now, but my understanding, my background's in consultancy way back and in the power sector, and I'm used to if there's a bit of a power station making a particular noise, it makes that noise consistently, and the limit is 3+ background or background or whatever, and there's certain things that you apply to it. Is that very different in terms of what is being experienced here? Because if not, then the frequency thing doesn't really make much difference, really. I appreciate that residents may feel different.
Chair, Councillor, the original permission for the site has no limits on either the number of takeoffs and landings or a noise limit. Principally because once the aircraft leaves the ground, it falls outside the remit of statutory nuisance, and it would fall down to probably the CAA to investigate, but I suspect they probably wouldn't look at that in much detail anyway. Aircraft noise is aircraft noise, and obviously the only thing that we've had to consider is environmental protection. It's just been the impact on that additional hour in the morning and the evening.
Thank you. So just on the CCA, it is CAA bit, can you just sort of expand on that? What do they do? Because it's been mentioned a couple of times, or at least, that there's no relevance at all with the CAA. Is there, and what can they do for residents, and how does it differ from what we do?
The Civil Aviation Authority is the regulatory body for any aircraft in flight. I think probably the only one distinction is there's a piece of legislation called something along the lines of the rules of the air, which pilots must have to follow, and I think it's at the discretion of the Secretary of State or somebody within central government can enforce those rules in terms of breaches, but they tend to be more things like health and safety that rather than noise limits or whatever.
So when it comes to, and sorry, I've added more questions, when it comes to circling around in a particular pattern and creating a noise for residents and so on, who controls that? Is that us through some form of management plan, even though they're in the air, and we can record the noise, or is it the CA who control that aspect?
Right. Well, in terms of circuit sort of routes, as I mentioned earlier, the airfield themselves have what they call advisory sort of circuit routes. One of the matters you need to understand is that there are different types of airspace and throughout the sort of UK, and essentially there are different levels of control over different types of airspace. Now, the airspace above Airshot Airfield is what's termed Category G, uncontrolled airspace. It's not subject to any kind of air traffic control. So it's different, for example, to Newcastle Airport in that respect, in that you don't have an air traffic control tower that can dictate exactly where aircraft should be when they're in the air approaching or leaving the sort of airfield. So essentially, what we have at Airshot is that the airfield themselves have advisory circuit routes, which they will encourage pilots who are training or who are coming to and from the airfield to follow. The difficulty you have, though, is that it's not always possible to stick rigidly to those advisory sort of routes. That there can be circumstances where a pilot will need to depart from those routes. For example, there may be adverse weather conditions of one sort or another. Different types of aircraft may dictate what circuit, whether you can follow a circuit or not. The number of aircraft already in the air above the airfield can be a factor, because obviously you have to maintain a certain distance between aircraft when they're sort of airborne. So again, if there's somebody else in that sort of circuit, you need to move out a little bit, to make way for them. So these are advisory sort of routes, and we feel as officers that the best way to regulate adherence to those advisory routes is through the management plan sort of scenario, because you.
Do you actually have the teeth in there, though, or not?
Well, you have teeth in the sense that obviously we're recommending a management plan for a period of sort of, well, with extended hours for a period of 12 months. So obviously, if problems occur that are of concern to members, you don't have to grant another permanent. You don't have to grant a permanent extension of those sort of hours. But I think coming back to what my colleague said, my public protection team, you do need to bear in mind here as well, as I said earlier in the presentation, that is that what essentially you're considering here are the extended hours. So the extra hour in the evening and the extra hour in the morning. The airfield already have. There have already been 2 previous permissions, so we're not looking at the principle of the use of the site by aircraft. It is very much the matter of these extended hours.
Last one, Councillor, because I have another councillor who wants to come in as well. Councillor Wearmouth.
In terms of this position of someone coming in and in terms of this position coming in, someone coming in and dealing with complaints, how is there any advice or anything that you can put in place to make sure that they don't end up talking about chickens or all of these other things, which doesn't seem very much a good use of anybody's time necessarily? That's a civil matter versus legitimate complaints regarding the practice that goes on in the airfield, really, I guess, and how on earth do you deal with that?
Right. Well, yes, I think the wording we've suggested in terms of the framework for the management plan caters for that scenario. So essentially, what it's suggesting at the moment in terms of the framework is that consideration will need to be given. As I say, the way things would work would be that there would be an opportunity for complainants to either complain to the airfield or directly to the county council. The airfield already do have a complaints system in place via their website where you can make complaints, but we understand that yes, there are some residents who don't have faith or confidence in complaining directly to the airfield. That's why we're suggesting that the management plan provides for complaints direct to the county council. So there will be a filtering process that will need to be gone through, and obviously if a complaint relates to a matter that over which we don't have any jurisdiction, then obviously we'd have to make clear to the complainant that that's the case, and obviously direct them to the appropriate organisation, which, as I say, may be the Civil Aviation Authority if it's a complaint about pilot behaviour in the air, for example. Again, if the concerns are around military activity, then again there is a separate military aviation authority which is part of the MOD that can handle complaints around the behaviour of military sort of pilots, low flying, things like that, and what have you. I think we also mentioned in terms of the parameters for the management plan that there would need to be some thought sort of given to, well, what happens if we respond to a complaint, but as I say, a complainant is unhappy with the response that we've given? Is there some kind of I don't know, is there some kind of appeal process or what have you, or second hearing that? But these are all details that need to be kind of looked at in terms of exactly what's in the management plan. We're just providing a framework in terms of the condition wording that we're suggesting today.
Councillor Dickinson, if you can still remember your question.
Oh, it was that long ago. Thank you, Councillor Wearmouth. I have a little bit of sympathy, as usual, with Councillor Dodd on some of his comments in relation to the fees and the costs, etc. But I would like to go back to what Councillor Wearmouth said not long back about teeth and about some of the monitoring and other advisory notes that this very committee put on in Town Hall a couple of years back. Now, until this report came forward, I hadn't heard anything about breaches, hadn't heard anything about any of the other things that had taken place. So it really refers back round in a circle. Now, I'm not suggesting the council or committees going round in a circle, Chair, under your stewardship, of course. But back to Councillor Sanson's original point about it being reported to the committee and it given a little bit more depth and scrutiny to what is actually happening, so that residents and the airfield can hopefully kind of work together or coincide in a more open way. And the only way to do that is to bring it to a public meeting like this. But I just do worry about where the cost will be picked up, and Councillor Dodd refers to the large international airport and other things that make noises and whatever, and we do need to put measures in place, but we also need to ensure that we don't set a precedent that the council will deploy resources to ensure that these things are monitored without the funding being accumulated from somewhere. So I think that's just a really important point, and I think you touched on it, Chair, as well, about how we gain that money back. Thank you.
Thanks for that, Councillor. I think we've exhausted all the questions, so we need to go to debate, but I need a proposal and a second, please. Councillor Sanderson.
I'd like to propose the recommendations, but with an amendment.
Could have a seconder for that, and then we can go to debate.
I'd like to propose that we go along with the recommendation on the paper, but that there should be a small change to 03 on page 40.
Propose that we can go to make a proposal quickly, get it seconded, then we can go to debate, and then you can. I know you like to be away early, Glenn, but yeah.
Yes.
Could make a proposal.
I propose that we do that.
Right. Have we got a seconder? So we can. He has. You should listen.
Sanchez wants an amendment.
Yes.
What's the amendment?
Right. Shall I read the amendment then?
Yes.
The amendment is on page 40, section 03. Within 2 months of the date of this permission, a management plan concerning airfield activities shall be submitted to the local planning authority and will be then referred to the first available Castle Morpeth Planning Committee for deliberation of the proposed plan and the resourcing of its function.
Okay. Do we get that, Liz? And can we have a second? Councillor Bourne has seconded that. Now we can go to debate. Does anybody? Councillor Dodd.
Just a question: is that legal? What's being proposed? Because the alternative would be to defer with the plan. Otherwise, we would grant permission, and that would be it. Under my planning experience of 30 years.
I tend to agree with you, but I'll refer to Liz if you can give us an answer on that, please.
I might just like a couple of minutes to have a chat through with Jeff and Joe, because it is important. I mean, obviously, the discharge of that condition 3 is a process, and we can always note that it's got to go. But I see, Councillor Sanderson, you want the belt and braces of it written in there, that it is returned to committee. I think, like we talked about at the beginning, it's quite feasible to be able to discuss the resource, but it's the financial implications that I just need to be clear about. And like Councillor Dodd says, then we're left where we've got this potential 12-month consent. But please note that the condition doesn't allow the changes until we have agreed this plan. So if this is not agreed, then we would have to come back in any event.
Can I?
I think I've talked myself through it anyway now.
Could I provide it? If we defer this until we have the management plan in place, would that be acceptable?
No, because
I don't think that's what.
Sorry, with the best will in the world, I think deferring it actually is not particularly helpful, because I think what we've seen tonight is the relationships are such. There are issues on both sides. Come on, the airfield has a business to run, and it's important that that is recognised, just the same as the local people have their voice and have their privacy and have their quality of life to be considered. So I think deferring it is not helpful. What I'm simply saying in this is that there is just another step to this particular condition, and that step just means it gets referred back to the committee for a look at what the proposed management plan is, and to also at that stage excuse me, and also at that stage to consider the resourcing, and that's all I've said, the function of it.
Councillor Wearmouth.
Thank you. I'm quite sure, and forgive me, Liz, if I'm misrecalling, that we have had conditions come back which is subject to before. I'm sure I've sat through, certainly on strategic planning, 3 or 4 occasions where that's happened. So I don't disagree that it's legally possible. It's an entirely different question as to whether that's what people want to happen and sit through another one of these. You know.
Councillor Bourne.
Thank you, Chair. Obviously, I don't have as many years' experience as Councillor Dodd, but I think it is quite clear that what Councillor Sanderson is proposing is simply that a discharge of condition is referred to a committee rather than decided by an officer, which I think is perfectly proper. I think
Liz?
That's quite not uncommon.
Yeah, Liz?
Yeah.
Right.
Yeah. I think, as I say, in terms of the issue of resource, as I mentioned earlier, we are suggesting a further sort of section 6 is added to the wording of the condition which requires that the matter of resource to be looked at in detail as part of the management plan that's brought back to committee for a decision. In terms of putting into the wording of the condition that it must be referred back to the committee for a decision, I think my suggestion would be that rather than doing that, that it's just made very clear in the resolution that as I say, that the matter of discharge of condition 3, which is the management plan condition, is brought back to Castle Morpeth Local Area Council for a final decision and not delegated to officers.
Can I say I'm surprised at the nervousness?
2 seconds, Councillor Sanderson. Can I bring Councillor Dickinson in first, and then I'll bring you in, and I think Councillor Wearmouth.
A little bit of order, yeah. I'm sure the leader of the council isn't getting upset about this, but I just like to aid the contribution potentially. I think it is absolutely clear and needed to come back here. Agreed. I don't think what we're doing here is giving an open blanket. I think what we're saying is we're providing a safety blanket, and that is that it comes back here, it's referred. It's very unusual for me to have any comfort in a resolution offered by Councillor Sanderson, but on this occasion, I think the robustness of it coming back to a committee in 12 months' time and not going to delegated authority is a much better position for this. It's better for the business, but it's better for the locals, and it's better for the council to be seen to be taking this seriously on both sides. And I just think it's really important. And I think Jeff's resolution in the recommendations covers off the resource, but we do need to look at that as a separate thing.
Before I bring you in, Councillor Sanderson, because I'll get you to propose it and move progress, I'll bring in Councillor Wearmouth.
Yeah, thank you. I think the only bit of nervousness I have around this, and if I understand correctly, it's to come back in 2 months with a sign-off of this condition rather than, and maybe we will see something in 12 months, I guess, as well, so if it's looking for an extension, would be whether that's actually feasible in the schedule of things, because that leaves an awful lot of work probably to do in 6 weeks rather than 2 months. 2 months is all very well and nice, but if you've got to write a report and bring it back here, there's a kind of bit of work involved in that. So is it practical?
Yeah, again, just to clarify that, again, if you look at the wording of the condition in your report, what it requires is that the application to discharge the management condition is made within 2 months. So there will still be an application process after that 2-month deadline, as it were, or that the application to discharge the management plan condition has to be submitted within 2 months. So essentially, what would... So essentially what would be submitted in 2 months if the recommendation is agreed, what would be the airfield would be required to submit within 2 months a planning application to discharge that condition. So that would include, as I say, a further draft of the management plan. As part of the application process, there would still be opportunity for discussion to take place with officers on the detailed content, and then whatever is agreed with the airfield, obviously there can be consultation on that application with the parish council, with other interested parties. As a result of all of that sort of work, after the application has come in, a document will be arrived at, and then that will be brought to Castle Morpeth Local Area Council for a final sort of, decision as to whether that's acceptable or not. So it may be, as I say, our time scale for dealing with discharge of condition applications is the same as your standard planning application. So it's potentially another sort of 2 months. So you're potentially looking at 4 months before, as I say, an application, the management plan is brought back to the committee for approval.
Right, thanks. I'm going to go to Councillor Darwin, then I'm coming back to Councillor Sanderson and see if he wants to make his proposal. Councillor Darwin.
Thank you, Chair. If I understand this correct, so the aircraft won't operate any differently until the management plan is in place and it is brought back to this committee to go forward. I think that's a right and sensible thing to do. I'm just not sure as to, and I think Liz alluded to this earlier as well, sorry Jeff, I did hear what you were saying there, but just to be sure, is this 2-month period sufficient to get that management plan robust and decide who's costing the officer's time? I'm just wondering whether, is there any difference to deferring this application for a period of 2 to 4 months, or is the condition to grant it pending the management plan coming back to this committee I just, what would be the best way forward, Liz? Would it be deferred, or would it be to grant this with the management plan come back? I'm just not convinced 2 months is sufficient to allow that to come back and be robust at this committee.
So
If I get
I
that
think
point
the
correctly.
option mooted by Councillor Sanderson, which I think we still have to have a seconder for. Have we got a seconder?
We've got a seconder, Councillor Bourne.
Right.
But I'm going to get Councillor Sanderson to come back and repeat
Is a feasible
it.
way forward. Remember, they've just got to make the application within 2 months. And I would expect when that management plan comes in, there may be things that we want to have further detail on. So it may then take more than 2 months before it gets back to committee, because we will be having, we will already have a level of scrutiny on it. So it is unlikely that it'll be back in 2 months, but the key here is that the applicant must have that in with us within 2 months.
I see. So it can come back. It might not come back to us in 2 months.
Correct.
And then the conditions won't be relaxed until it comes back to us and then agreed. So if we disagree with it at that time, we're back to that's fine.
Great. I'm going to go back to Councillor Sanderson to make his proposal again, please. You've heard what Liz and Jeff have said.
Well, I propose that we follow the recommendations, Mr. Chairman, but we add that to 03 on page 40, the following, that it should be referred to the local planning authority and would be referred to the first available Castle Morpeth Planning Committee for deliberation of the proposed plan. If you wish, I will remove the bit about the resourcing, but I can guarantee that I will want to raise it when it comes back. And I'll tell you why. I don't think we need to be so concerned about this. It is supremely important that there is a management plan that's resourced by an independent, impartial person that is seen as such by both sides. So it's in the operator's interest, it's in local people's interest to make sure. And if that means that we have to identify some resource within the county council to carry out that impartial position, then I will be arguing for that. But I'm prepared to leave it for today if we can just get the first part agreed, if possible. Thank you.
My concern is the costings. Councillor Bourne,
I'm happy to second that proposal.
Right. We've had a Councillor, I'll let because you haven't spoken.
I just wanted to express just a very brief note of caution. I do have concerns that as a local authority we are stepping in to effectively police a private business. We should be able to rely upon any business to operate within the rules and regulations that are set out. And whilst I appreciate all the reasons why, and I can see the breakdown of the relationship between the business and the local community, it still concerns me that we are putting ourselves to work and expense in order to effectively make a business work in the way that it should work in the first place. I just want to express that note of caution. Thank you.
Chair, can I just come back on that, Councillor? You know, using management plans is a very typical and usual step that we have on some contentious applications or unusual applications. Generally they're for quarrying or open cast mines and what have you, and they are a very effective tool to continue liaison between the community and the operator or the applicant. And on this type of application, we think that it is well placed, but we don't use it often. And you're right, we don't like to use planning as a tool to manage people's businesses, but it can be an effective planning tool at the same time. Thank you.
But just before we go to the vote, Councillor Dickinson.
I just want to pick up on Councillor Murphy's point, because Councillor Sanderson strayed off a little with the late change on the motion there, and it is around that open cast plan or those other plans would all be dealt with in-house by council officers, etc., etc. Part of the planning process, part of the department, part of the fee, part of everything else. We've just heard that we're talking now about an independent person, and that we'll be arguing for council resources for that. You know, that doesn't sit easy with me. That's totally different to what we were saying before. So.
Councillor Sanderson, and then we'll make progress.
I thought I made it quite clear that I'm prepared to drop the part about the resourcing of this for the time being. Yep. I think it's more important to get it back to the committee and then everyone can have their say, whatever they feel. Thank you.
I agree with that. I think you and I Councillor Dickinson have the same fears, but that, I think, has resolved it. Right, we've had a proposal.
Chair,
we've had a...
Can I just confirm that Liz is happy with the additional wording?
Yeah, so I think it's less wording actually, is that the case? So it's an amendment to condition 3. So I think, Councillor Sanderson, what you're proposing is the recommendation along with the amended conditions already proposed by the officer, along with the following amendment to condition 3, which is within 2 months of the date of this permission, a management plan concerning airfield activities shall be submitted in writing to the LPA, and that it will be returned to Castle Morpeth Local Area Council to review that proposed plan.
And is that the application for discharge of the conditions?
Of condition 3.
Can we add that in?
Yeah.
And is that okay, Councillor Bond?
Thank you.
Great, thank you. We've had a proposal, we've had a seconder. Could we go to the vote, please? All those in favour of Councillor Sanderson's proposal? 8. 8? I'll take it. Chairman, I never vote. No, I don't. Unless it's a...
Are you abstaining?
Yes.
8 in favour, 1 abstention, so that's carried.
That's 8 in favour, 1 abstention. That's carried. Thank you for that. Right. So. Yes.
Yeah, there's loads of people have asked.
We have technical difficulties. I can't even say the word. So we could have a comfort break for 5 minutes just while they restore the technical stuff. Right, councillors, technical difficulties have been partly resolved, but we're going to crack on. If Councillor Dickinson speaks, that's when we'll freeze the frames and the sound.
Of course, Chair.
You had trouble getting that off your face. Right, thank you, councillors, for your indulgence. The next planning application, 20/03851/COU, change of use from field to constructing a riding arena, 22 metres by 40 metres for private use. And I think Mr. Lang is going to take this one, please.
Thank you, Chair. Good evening, everyone. So, as the Chair has said, this is for a change of use from a current current field to provide a private riding arena, for 22 metres by 40 metres. The site is just to the northwest of Upham. You can see the U6003. Yes, U6003 is the road running by it, and as you can see Upham just down to the southeast. I got lost my east and west mixed there. Sorry. So here we have the quick site plan. We can clearly see there the road beneath it with the access in the bottom right corner there, and a simple overlay of the field. To give a bit more of a visual there, we have a cross-section of the fencing to be used. So it's a timber fencing with a chopped rubber surface. I just quickly take you back here to the, as you see on the photo overlay to the north of the site, you can see the existing stable block, which belongs to the applicant, which is linked to this site for private use. Site photographs, this just give you a bit more clarity from the entrance. Top left is the front entrance looking towards the hard surfacing. The arena will be on that field on the left there. To the photograph top right, you'll see then the boundary fence and the road that goes up to the stables. The bottom left photograph is standing at the entrance to the site looking onto the road. And the bottom right photo shows the public right-of-way running directly to the north of the site. So officers are meant to recommend approval to the site with conditions. Just on the conditions. Obviously with the standard in accordance with approved plans and time frame limit. on for 3 years. Also, I'm also proposing a condition to restrict the use for private use only and for no changes of uses, just regardless of permit development rights. For no lighting at the site, temporary, permanent, personal, just no lighting at all, because obviously it is in the open countryside, although it's not green belt. It's still something we want to strict lighting for amenity reasons and for ecology reasons as we get into the countryside. And bear with me, the sixth one is for on recommendation of the public rights of way officer. The number 1 footpath is where you can see running directly north to the site. That's to be kept clear and safe at all times. So out there. We have no standing objections from consultees, but we do have 3 objections from residents. There were several issues that were raised, and they're all as detailed within the officer report. Just as a quick update, unlike the report where I put condition 3, I just like to tweak the amendment there for condition 3 is to make sure the access is installed and maintained prior to the first use. We'd like to make that maintained in perpetuity. So as long as it's in use, that access is being maintained. And condition 6, the condition doesn't identify the footpath, so we just label the footpath as per the public right of way comments as number 1 footpath of them. I think that's a quick. It's quite a short and sweet one.
That's great. Nope. For public speakers, we have one person who is objecting, which is Dorothy Moore. You have 5 minutes from when you start speaking. Thank you.
I own the wood directly north of this application, and as a geographer have been trying to improve its biodiversity. I have right of access through the proposed site. I am a horse owner competing nationally and have never come across an arena so dissociated from its buildings and which involves crossing a public footpath. Why does the online officer's report not tell us what policies this application is judged against? Recent arena applications appear to be judged against Northumberland local plan. These all fall within the curtilage of associated steadings, contrary to this one. I do not understand the officer's comments that this application is not in the green belt, when the previous application he dealt with, which was 21-01020 full, states that it is, as does 19-03885 full for the stabling, and map 3.2 Northumberland Quay diagram in the local plan. Policies used in other applications are, quote, ENV2 3A, permission will be refused unless it can be demonstrated that the benefits of the development clearly outweigh the harm. ENV 3.1E, the contribution of the landscape to Northumberland's environment will be recognised. And point 3, quote, ensuring that new development on the edge of settlements does not harm the landscape character of the settlement edge and where possible it has a net positive impact, unquote, which it doesn't. And point 5, quote, the potential impact that a small-scale development can have on landscape in sensitive rural settings will be assessed. As well in point 6, any net negative cumulative impacts of development on the landscape character, unquote. This application does not contribute positively to these points, it merely detracts. It creates a standalone feature within a separate field bounded by an ancient hedgerow and woodland, which alters the topography of the landscape, altering the rural environment with its rubber surface as viewed from the public footpath. This will be additional pressure at the northeastern edge of Upham, where a landowner is trying to put in a caravan park. Reference 19-0030, miscellaneous. Considering policy QOP, 1, does this application, quote, make a positive contribution to the local character, including landform and topography? Does it integrate the build form of the development within the site overall? Unquote. My answer to these would be no, because it alters it and is a considerable distance from the existing buildings. Policy QOP 2.2 states that, quote, development which would result in unacceptable adverse impacts on the amenity of neighbouring users in terms of both individual and cumulative impacts will not be supported, unquote. The application is clearly visible from the surrounding woodland, adjacent road, public footpath, where the route to the arena dissects it. The siting of the arena is hazardous to the right of access users, the footpath users and the applicant. Currently, 8 horses are kept as a herd by one person, and taking one horse away creates anxiety amongst the rest. The arena is 100 metres from the stables, passing through 4 gates, across the vehicular rights of access for us and the public footpath, both of which are recorded as separate entities on our deeds. An agitated 400-kilogram horse can cause a lot of damage, and I have first-hand experience of this. We have been and seen users of this footpath trapped by these horses. Walkers and dog walkers invite their curiosity, and this is when accidents happen. The officer puts great store in this being for private use, as with the earlier stabling application, but additional horses have been kept there as liveries. The land had covenants stipulating the position of any new fencing. This was ignored, displacing the original footpath route without consultation to NCC or ourselves. If it is for private use, then why, after the land purchase in 2019, was a large area of hard standing with additional fencing and gates across the footpath added? And this was next to the proposed arena. And why is it to be located so far from the stables? Why should we and the residents of Upham have to negotiate these additional hazards when using what is a public footpath? In conclusion, this is a standalone development in a green belt, which creates hazards for football.
Thank you.
I just had one sentence left.
Sorry. Right, councillors. We go to questions for officers. Councillor Bourne and Councillor Dickinson.
I think the simple question is, obviously the objector said it's green belt, you said it's not. What's the answer?
From looking at the maps, I thought it wasn't the green belt.
Do you still think that?
I have to check I have to go back to I don't have the UP map in front of me. Can we bring that up now?
So, yeah, all the constraints will be brought up when an application is validated and registered, and that comes through to the case officer. So that happens as part of our validation process. That said, you know, we've got a speaker here tonight that's saying it. It would do no harm. What we can give you is an undertaking that, depending on the outcome of your decision tonight, we will double check that. Obviously, if it's green belt, we'll be rerunning the assessment of the application, and we wouldn't issue any decision.
Thank you. Councillor Dickinson.
Well, it was just along David's point, really. The applicant quoted 3 applications where this section of land's been deemed to be either in or out of the green belt, and at the time of assessment, the officer says he thinks it was in. However, we've got 3 reference numbers which indicate it is in, not out. And I think that's a critical point on this particular application.
Yep.
So yeah, just to the green belt in that area is not settled by reference to a line on a plan. It's actually done by verbal description on areas and boundaries. So it can be the case that in and around that vicinity, because I know that is the outer edge of those descriptions, it could be that some land is within the green belt, yet adjacent sites are out with the green belt. And that's why some of those decisions that's been referenced, that may be the case. I don't know.
Councillor Dodd.
Yeah, I mean, green belt's a funny one, because some things are allowed in the green belt that are greenish stroke, you know, livestock stroke, whatever. The green belt seems to be used as a tool to stop everything, but I don't think this would have the same sort of test as a building, a dwelling, or a whatever. So I think we do need the advice. If it is, it isn't. Mm-hmm. But my experience tells me this wouldn't be covered under anything.
Was there a question in there, Councillor Dodd?
Yeah. I think you were asking a question there, and just to agree with you, yes, some uses in the Greenbelt are acceptable, and a quick look at the Greenbelt policy includes an exception to. So as you know, we you know, most development in the Greenbelt is inappropriate, but there are some exceptions. One of them is the provision of appropriate facilities for outdoor sport, outdoor recreation and so forth. So it may be, however, it may be that it's acceptable. However, we haven't run those Greenbelt tests, and I wouldn't want to recommend that we do that tonight.
Cool. So Wearmouth and Councillor Dickinson.
Thank you. So there's two places that you can get Greenbelt policy. The first is from the safe policies in the local plan and the structure plan, and then the second is from the emerging local plan. Which one is taking precedent at the moment? We've got putting significant weight to the local plan now, and can we not easily find it on a document somewhere?
So. No, it's the emerging plan is a material consideration. It is not your starting policy place. So the policy, so the starting position for assessing this application is your development plan, which is the Castle Morpeth District Local Plan, and you're right, policy S5 of the spatial strategy. So that's what I wanted. That's what I'd like to check.
Yeah. Councillor Dickinson, I'll come back to you.
Yeah, thank you, Chair. It was just along the lines around Greenbelt and potential use for prevention of all sorts. I have sympathy with that. However, what we are talking about here is, and I have sympathy about livestock and other things and those types of things being allowed. But on these plans, we're talking about inserting rubber membranes and creating quite a structure that would change any kind of Greenbelt usage, and all it be for horses, etc. It is putting down non-eco-friendly surfaces and materials into what could potentially be a green belt piece of land. And could it not be on a different type of surface if that was the requirement? But we have to deal with what's in front of us, and if it is in the green belt, I think it is important that it's clarified because of the materials and surfaces that are proposed as hard standing on that.
That was a nice question, Councillor Dickinson. Councillor Wearmouth.
So I'll try to frame this as
please.
Looking at the green belt map in the emerging local plan, it definitely is in the green belt. I guess that the question comes.
Could I just interrupt you, Councillor Wearmouth, because I think we actually have an update here about the green belt. So I'm going to hand it over to Jeff or Will.
Yeah, sorry, I've just had a look at the proposals map in the Castle Morpeth District local plans. That defines settlement boundaries for the various villages within the former Castle Morpeth area. And yes, from what Will is telling me, the site lies outside of the settlement boundary. So for that reason, it would fall within the S5 green belt extension sort of area. So it is within the green belt, yes. Yeah.
Is there a question coming to your mouth?
No, actually,
Right, thank you. If there's no questions, can we have if we want to go to debate, can we have a Councillor Bourne?
Can I propose we defer this until we get a definitive answer?
I was just going to ask if we could.
Agreed.
Yeah.
Agreed.
We've got to demonstrate that we have assessed it against the Green Belt policy, so thank you to the Speaker, and we will assess it and bring it back now.
Could we just, for clarity, have a show of hands for that's 1, 2, 3, 7.
I seconded it.
Yep. 7, 1 abstention. Yeah. Thank you. Right. Back to the agenda. I think we're nearly through. Appeals update. I haven't any. Liz, has any appeals update?
There is a report there, members, for you to note, unless you've got any questions.
Date of next meeting is Monday the 8th, November 2021. Urgent business, I haven't been told of any. Nothing coming up. Thank you, ladies and gentlemen, for your attendance. Thank you very much. Thanks, Liz and officers.